My name is Tate Reeves. I am the Lieutenant Governor of the state of Mississippi, and my task this morning is to very quickly lay the foundation of what brought me to support the reform efforts that my colleagues in the House and the Senate are going to talk to you a little bit about. In essence, my background is in economics and finance. I worked in the private sector prior to getting into government. I then served 8 years as the state treasurer. And so on this particular effort, like virtually every other effort that we undertake in state government, we came from it from a fiscal standpoint. When we came into office in January of 2012, we inherited a budget that spent about $460 million in one-time money on recurring expenditures. And we had a goal that we were going to eliminate that use of one-time money over a 4-year period. I'm happy to report, by the way, thanks to this and several others, we were actually able to do it in 3. But because we also knew that we were not going to be able to accomplish that just through economic growth and just through revenue growth. We were going to have to be smart. We were going to have to find ways to save money on government. And so I tasked my staff immediately following the 2012 legislative session to go, because I have a staff member assigned to every state agency, go look at things and figure out ways for us to save money. One of the things that we found was in the Department of Corrections. And what we found was that since 2005, our corrections budget had gone up by about $120 million. That's a 48% increase over a 7 or 8 year period. Not shocking. However, what we also found was that over that time period, we only had an additional 1,000 prisoners in our system. So our prison population had only increased by 4%, but our cost had increased by 48%. So as any conservative would do, I started asking the question, well, why is that the case? And what we found is, obviously, Mississippi has the second highest incarceration rate in the country. We found that 1 in every 2.3 prisoners that were let out returned to the system within 3 years. We found that approximately 3/4 of our prison population consisted of nonviolent offenders. And finally, we found that in 2012 alone, we had more offenders enter prison from supervision than from new offenses. So obviously, we had serious challenges with those who were in the system, and we had to do something about it. To make a very long story short, because I don't want to take much time today, but to make a very long story short, what we ended up doing is in the 2013 session, the Senate passed some reforms that did not become law. My friend, the Speaker Pro Tem, had a bill in the Mississippi House that put together a study committee, and I will tell you, he came to meet with me about this. I was very reluctant regarding the study committee to begin with, because my general approach on study committees is people who don't want to make tough decisions have studies. But I will tell you, in this particular instance, it was definitely the best possible thing for us to do. And the reason for that is we brought all interested parties together, the prosecutors, the mayors, the supervisors, the legislators, members of the judicial branch, and they sat in a room for nearly a year, and they came up with really good ideas. So a lot of the politics, the challenging politics for some of us, were really worked out together so that we all came out of the room going into the 2014 session with a plan. The plan that ultimately passed, we believe, is really, really good public policy that has the added benefit of saving us $266 million over a 10-year period. And so with that, I'm going to turn it over to our Speaker Pro Tem of the Mississippi House, Greg Snowden.
Thank you, Governor. I want to start by saying how much I appreciate, and I know my colleagues do, this positive recognition. Mississippi gets its share of criticism, and some of it justified, some of it not, but it's nice to be in a positive spotlight, and from the bottom of my heart, I want to thank you all for that. We did have a very positive effort this year, thanks to leadership in the Senate and the House. I'll start with a disclaimer. I am a lawyer. I have, in the course of, I've been practicing law since 1979. I've represented, I think, exactly 1 felony defendant. That was my first year out of law school, because we didn't have an established public defender system then, and you were appointed. And the thing I remember most about that representation, I was astounded to find out that police detectives could actually, it was a check endorsement scam deal, and the police could actually get fingerprints off of paper. I mean, that's not the sort of thing they tell you in law school, and it astounded me, and I've got to say it was an unpleasant thing for my client to come to recognize that was true too. But I am a lawyer, but not a criminal lawyer. But I have served in the legislature 15 years now, and obviously, we have a fiscal problem when it comes to corrections. The Lieutenant Governor is absolutely right there. Without any change, we're projected to spend $266 million additional dollars over the next decade, not money that we want to spend. Somehow we have to find a way not to do that. But what really personally motivated me, and has for much of the 15 years since I've been in the legislature, is what I have seen as a growing disconnect between the correction system and the criminal justice system. And it's entirely the fault of the legislature over a period of time. Before I got in the legislature in 1995, we instituted a truth in sentencing law requiring violent and nonviolent offenders to spend 85% of their terms. By the time I got there in the early 2000s, it was already being dismantled because costs were rising, and there was a really very haphazard way of going about it. Ultimately, what the legislature did was abdicate its authority and responsibility to the corrections department. Said, you know, here's your money, you fix it. And as a result, what happened in the courtroom didn't matter at all to what happened in the correction system in the courtroom at the time of sentencing. And the sentencing issue is something I do want to talk about just very briefly, because I think, for me anyway, it was at the heart of our problem. No, the judge didn't know, the prosecutor, I mean, most of these are plea bargains, as you know. Nobody had a real clue how long an offender could be expected to serve, certainly not the offender. It was, you know, it just, you were sent to the correction system and you got out when somebody in corrections decided to let you out. I have two little stories I want to tell you that I think illustrate this problem. I have a good friend who's a circuit judge, trial judge in Lauderdale County and Meridian. About 2 years ago, he had a case where a PTA president had stolen $25,000, $30,000 from a school fund. Well, the district attorney did not want to recommend that woman not serve any time. She was obviously guilty. Her attorney decided to plead in the blind, as they call it, you know, without a recommendation, leaving it entirely in the judge's hands. The judge, who I know, very conscientious, very good judge, wrestled with that. I mean, she's clearly a nonviolent offender. She's not going to be a threat to anybody, but she stole money from kids. And it's a pretty big issue in the community. He determined that she needed to spend some prison time, and he gave her a sentence that she wouldn't have served a complete year even. It was a fairly moderate sentence. Well, her attorney, as is the right to do, of course, he wanted house arrest for her immediately. He didn't want her to spend any time. But he filed a motion to reconsider the sentence. That's fine. They set that for a month away. Well, when the next month comes, the judge walks in, and there in the courtroom, in the meantime, of course, the offender's been remanded to the custody of the Department of Corrections. She's sitting in the courtroom alongside her attorney, and he kind of sheepishly stands up and informs the court that, well, we're going to withdraw that motion to reconsider. She's already been processed, and she's got her ankle bracelet, and she's out. And that's just an illustration of the problem. We have, for better or for worse, and it can be the one, I suppose, we have elected trial judges. And over the course of the last 15 years, you know, judges come up to me and say, I get a citizen on the street. He says citizen, he means voter, comes up and says, you let John Brown back out. You know, he's the guy that knocked over the convenience store or whatever. He's out already. Well, the judge, from the first, didn't let him out, and second, even really had no clue he was out. But this disconnect was something we had to address, and the purpose, one of my driving purposes for the task force was to find a way to do that. Now, obviously, taken alone, something like that would probably just increase cost. And that's the beauty of this task force, as the governor has mentioned. My bill, House Bill 1231, I think was the number, in the 2013 session established this task force. And if you have the little blue handout, I'm not going to go down this list, but if you just look, it's the back cover. It lists the people that serve on this task force, 21 people. And that's as broad a group of individuals representing just about every conceivable stakeholder that you will find. It was so breathtakingly broad that I predicted to people that, you know, they're going to either come up with some wonderful recommendations or nothing at all is going to happen. And I'm glad to say that it was the former. At the end of the process, and by the way, my colleague 2 seats down from me in the House, Representative Gibson, served on that task force, and it was his bill that, the bill that resulted in the reforms we're talking about. But 19 recommendations of that task force that we unanimously recommended for the legislature to take action on. And it just was an amazing thing to see the thing come together. And I agree with the Lieutenant Governor. Task forces and study groups, as a general rule, are not something to be desired. We have a bad habit, and I suspect a lot of legislatures do. When you can't get something done, we'll put a little saving face on it and call it a study committee or something. And this is not that case. This is the way we were able to get there. I do finally want to touch on one thing. I do want to touch on the politics of it a little bit. And it's interesting because nobody at home has asked me or even mentioned to me or breathed the possibility, is this something soft on crime? Is this something that's, is this a little risky proposition for you here? But as I move around the country, that's one of the questions we get asked. It's just kind of funny. And I was thinking about that, and Mr. Vickery in his comments as well. My colleague here, 2 seats down, Representative Gibson, very fine, talented attorney with Jones Walker Law Firm, large law firm. He is an ordained Baptist minister and a pretty fair country preacher. He is our chairman of our Judiciary B Committee. He handles all our Second Amendment matters. He handles our pro-life matters. This year he was blessed or cursed with having to handle what turned out to be a very contentious Religious Freedom Restoration Act. It just, this is a man, if it took Nixon to go to China, this is our Nixon. Representative Gibson, nobody in their right mind in Mississippi would even suggest that Andy Gibson is soft on anything. And he was the man that carried the spear for us very successfully in the House, and Senator Wiggins, who's also here to my right, in the Senate. And now it's my privilege to turn this over to them to let you know how they got the nuts and bolts of this thing through. But it was a team effort, and it was. We think it's something good. It's going to pay off big dividends in the future.
Thank you. Thank you, Speaker. It is an honor to be with you today. I'm Andy Gibson. I do serve as chairman of the House Judiciary B Committee, and it was my privilege to serve on the task force that's been discussed. I have to tell you, I was skeptical, perhaps the biggest skeptic on that task force, the 21 members that served together. But I think what became the turning point for us in our work was the realization that, yes, we were spending all this money, all these taxpayer dollars, but it really wasn't about the dollars. What we realized was the evidence showed that what we were doing in Mississippi just wasn't working. It was not working at all for the benefit of public safety. We had seen the dramatic rise in cost over the years, but we saw, based on our study, no clear benefit whatsoever to the public safety. We saw that we had a serious recidivism problem. No one had admitted that before the task force met and discussed these matters over several months. And what we realized based on the evidence that the primary driver in the increase in population was repeat offenders, offenders who had gone through our system, who had been incarcerated, who served time, and then every year we have in excess of 9,000 or so come back to our communities, and for one reason or another, they reoffended or violated a condition of probation or parole. In other words, their behavior had not been altered. Their patterns of lifestyle, of the actions and choices they made were not affected by having served time in Mississippi's prisons. So in addition to what the Lieutenant Governor and Speaker Pro Tem discussed about the sentencing need for restoration of certainty, we did adopt some true minimums for time served that were much needed. We actually adopted a classification of violent crimes that is a policy decision that the legislature made, and we limited house arrest to the authority of the judiciary. And we believe those, simply by bringing certainty to our system, will have an impact on crime, reduction in crime in Mississippi. But we went beyond that because we felt it was necessary to give our judges some additional tools besides putting people in prison. As the Lieutenant Governor mentioned, we were #2 in the nation. for incarceration, and really there were no other alternatives. We had adopted drug courts in Mississippi and had them in place for a few years, but frankly, there were mixed results. We had some very good drug courts, very good drug court judges who would apply these principles of rehabilitation and really wonderful programs. But then around the state, we have some that were less successful and a lack of uniformity there. And in addition to that, we saw drug use, drug abuse continue to be one of the main drivers of these crimes. And, nonviolent offenders make up about 45% of the total population. And so we needed to take this opportunity to adopt some policies that we believe would actually work to adjust and alter offenders' behavior, not just lock them up to have them reoffend 3 years later. There were 19 recommendations. I'm only going to focus on 3 policies that were adopted before I turn it over to Senator Wiggins. The first is on the subject of drug courts. As I mentioned, we had drug courts in place. We actually had a drug court judge participate in our task force, a very astute gentleman, and realizing that not everyone is a good candidate, as Speaker Gingrich mentioned. Not everyone is a good candidate for a drug court. You need to be able to screen these individuals. So we adopted a requirement in our law, House Bill 585, that our administrative office of courts, that's the administrative arm of our judiciary, that they come up with some evidence-based best practices for drug courts as to actually what does work, who is the proper offender to participate, where do we get the best results. And we added to the drug court goals the effective use of our corrections resources by redirecting prison-bound offenders to whose criminal conduct is driven by drug or alcohol dependence, to redirect those offenders to intensive supervision and clinical treatment available through the drug court. The administrative office of courts is going to develop the certification process. We spend a lot of state taxpayer dollars on our drug courts, and we're going to, in the future, as a result of these reforms, ensure that drug courts who are certified, who use the best practices, they're going to receive the state funding, and those that do not will not. We're going to actually make sure that we spend our resources on the drug courts that work, and that's going to be I think, the carrot approach to make sure this does work going forward to reduce drug use and the related crimes. We also expanded the categories of offenders who could participate in drug courts. Mississippi's law prior to House Bill 585 very limited in terms of who could participate. There were exclusions for anyone who'd ever been in trouble with the law before, for example. We felt that it was appropriate to give the judges who are in the best position to know if this person is a good candidate or not, to give them the discretion to make these offenders eligible for drug courts. Let the judges make the call. And so we expanded participation eligibility in drug courts as a result of this. We saw that property crimes were one of the most significant drivers of our increase in prison population, and our sentencing ranges were just wide open. Basically, the same property crime in one district might have received virtually no sentence for a prison term, 0, and in the neighboring jurisdiction it might be 30 years because our sentencing, the exact same crime under our laws provided sentencing ranges for 0 to 30 years or 0 to 15 years. And so when we looked at the data, the sentences across the state were all over the map, depending on which district you were in, which judge you appeared before. So we went to a value-based sentencing regime for those property crimes to make sure that the more serious offenders get longer sentences and less serious offenders get lesser sentences or alternatives to prison. And a byproduct, and I think an important byproduct of that, is the uniformity that's going to bring to sentences in our state, across the state. And then finally, our drug crime revisions that were put in place, sort of a similar theme there. For our drug offenses, 0 to 30 years. Depending on the judge, it may be closer to 0, it may be closer to 30. No uniformity in how we're approaching this. We went to a weight-based system. depending on the amount of drugs involved. I think the first tier is 0 to 8, and then a higher level is 3 to 20, and then a higher level than that is perhaps up to 30. But we did something that we thought was important, and I didn't want to miss this opportunity to mention, recognizing that lower level offenders who are under our new law going to be eligible for drug courts, they're going to be eligible for those evidence-based treatment practices. We need to give them that opportunity to change their behavior, but we actually adopted a trafficking law that is going to, we hope, interrupt the supply of drugs in Mississippi, a trafficking statute that will now involve a minimum 10, maximum 40-year sentence for the serious high-level trafficking of drugs, more than 30 grams of Schedule 1, 2, 3, 4, and 5, and more than a kilogram of marijuana. So the point is, we have adopted for these low-level offenders a variety of different alternatives to prison that we believe will work, and the evidence will show will work to reduce not only their dependence on drugs, but to reduce crime in Mississippi. And that's what it's about. You know, you could think about this as cost saving, but really and truly, and I think one of the reasons that Mississippians embrace this is we know that what we were doing was not working. It wasn't working to reduce crime. So let's try something new, and we believe that this bill will have that effect. Last thing, and I'm going to turn it over to Senator Wiggins, who can talk about some of the old war stories that we had in terms of challenges to this process, but we did adopt an oversight task force that will study whether, in fact, these reforms work. And the goal is going to be, is this reducing recidivism in Mississippi? That we're going to study that for the first time, and we're putting that in place right now. I'm excited about it. Senator Wiggins.
Thank you, Andy. My name's Bryce Wiggins, Senator, Chairman. I serve on the Judiciary B Committee in the Senate, and I think as everybody can see here, this was a team effort all across the board. And in the Senate, it certainly started with Lieutenant Governor Reeves and his faith in myself and his Judd B chairman and everybody working together. And I want to say there's a gentleman in here who, he's not up here, but he did a lot of work. You heard Lieutenant Governor Reeves mention his staff. Well, Kenny Ellis, who's in the back, he did a lot of behind-the-scenes work along with Parks McNabb, and they did the behind-the-scenes work while we kind of did the front of the stuff. So they did a great job. I'm going to kind of talk about the issues that we saw in getting the legislation through, and kind of the background of how we got there. Just a little bit of background on me. I, before entering the Senate, served as a prosecutor for 8 years. So the things that Representative Snowden, that Andy have talked about, I saw it in the courtroom on a daily basis. And the last trial I did before I left to run for the Senate, I sent a 14-year-old kid to prison for life for murder. And when you try a case and you hear the judge pronounce a life sentence for a 14-year-old, who, by the way, had done some drugs, all that, and you see the reaction, not of just the victims' families, but of the defendants' families, the mother, the father, the siblings, and they fall out in the courtroom because they know their son is going to prison for the rest of his life. This is an issue that affects families across the board. And Andy has said this is a family values issue. It is a family values issue for the reason I just mentioned, because it doesn't just affect victims, although I'm a 100% supporter of victims. It's what Speaker Gingrich said. It affects everybody. And I think what we mentioned about Chuck Colson is exactly the case. Just quick, some statistics. For that 8-year period, I would handle at any given time 300 cases at one time. In the district that I represented was probably, based on a caseload, was either the 3rd or 4th highest caseload in the state. we did about 3,500 cases a year. 80% of those cases were connected to drugs. Even if it was murder, even if it was rape, even if it was burglary or property crimes, it was connected to drugs. 80% to 85% of all cases were connected to drugs. I can tell you that what I saw, drugs hit everybody, whether you're conservative, liberal, Democrat, white, black, yellow, red, in some form or fashion had been there. And I concur with what Representative Snowden said, which is out in the community when this was going on, I didn't hear, you know, this is soft on crime, and nobody said that to me. The voters didn't, because I think they saw the issues and it's touched everybody. And so I think that was one of the things. So when we entered into this process, honestly, I probably had kind of the perception and the feeling that, you know, it was only the elected officials who were afraid to go forward on this, because the general public, they're out there seeing it. And so I think that's proved to be the case. I wanted, and also while I was there, you've heard both of these gentlemen talk about the distrust in the system. Greg's exactly right. What I saw in the practice was that the reforms that the legislature had done had created distrust in the system between judges and MDOC, MDOC and victims, I'm sorry, Department of Corrections, thank you. And what played out, I'll give you an example, is that, well, what I would hear on a regular basis in the courtroom is from the sentencing judge, and this is on a plea or something, he'd say, well, this is my sentence, I don't know what Department of Corrections is going to do, but this is what I'm doing. And then sure enough, it would be different. One of the tipping points in my area was a well-known family. Her son, who was at home after college on Christmas vacation, he was on Christmas, like the day of or day before Christmas, he was shot through a window by a jealous boyfriend of somebody he'd been dating. He died in the arms of his mother at Christmas. He was shot in the head, and case went to trial. Ended up, they couldn't find the weapon, so they pleaded it when it was a manslaughter, and he got 20 years sentenced, manslaughter conviction. Because of the changes that were put in place by the legislature, he was out in 7 years. Now, if you don't think that that causes problems and that causes distrust in the system, you need to think again. And that's only one case. I've heard of other cases as well.
Gentlemen, the reason that we've got these gentlemen here is to go through what's happened in Mississippi is severalfold. First of all, Mississippi ain't Massachusetts. If the voters of Mississippi, as Mr. Wiggins just pointed out, didn't take this as evidence that you were soft on crime, then in other states they're not going to do that either. Secondly, the comprehensiveness of the way that the Mississippi reforms progressed was something that we thought everybody else would benefit from hearing. And finally, the process that was developed, the most thorough process that I've heard in any state in terms of studying the problem, finding out what needs to be done, and then putting together a program that's saleable both in the legislature, to the governor, and to the population, and to the various stakeholders, is a unique and special opportunity for others to take a look at that. But there are other states as well that have made a lot of progress. We call this the laboratories of democracy, and interestingly, last evening I was at a sentencing reform dinner, and the MC pointed out that now there's pressure finally to reform the federal system because of the fact that in the states there are so many reforms taking place, and that they're starting to work, and that there's now evidence-based reforms that can be adopted federally. That's one of the things that the founders saw as the benefit of a federal system, is that different approaches can be applied differently. And the traction that this has gotten at the state level has been incredible. People that have signed on as champions of it, people who didn't begin until they began to look at the problem, became champions of criminal justice reform. We've got some folks here in the in the audience from a number of states that have been involved in criminal justice reform, sometimes comprehensive, sometimes piecemeal, sometimes ongoing, and all of those approaches are working in different ways in different states. But I think one of the things we want to do today is have an opportunity for some of them to ask questions of people who I think have done it right, and also to talk about what's going on in their states. You know, you're going to see after the break a tape from Georgia from Governor Deal. I used to be president of the NRA, and he sponsored a thing for us, and I made the mistake, and this is a man who's become a champion of this, I made the mistake in introducing the governor to saying when I'm not talking about the Second Amendment, I put on a different hat and I like to talk about criminal justice reform, and he's one of our heroes, after which he talked for 45 minutes about criminal justice reform, because he had become a champion of this and knew that it was not only right, but that it could be done in his state as it's being done in other states. And so we've got Representative Willard of the Judiciary Committee chairman from Georgia here. We've got other people from perhaps from Kansas and South Dakota and Kentucky, people not here from other states that have made the efforts, Judge Steve Alm in Hawaii, programs that are working, programs that are cutting down on recidivism and tangentially saving money for the states and demonstrating that the right thing to do can be done, and is something that voters have always had more sense in some ways than the people that represent them, and that if you talk to them about what works and doesn't work, you'll have their support. So rather than us go on, why don't we throw this open to some questions and some observations from some of the other states, and some of you may have questions for these fellows up here because they've actually done it and done it right.
I'm Ken Blackwell from the Family Research Council and Liberty University School of Law. And let me start out by saying that I believe in the wonder-working power of Christ, but I am grounded in both the New and Old Testament. Given that, and given my appreciation for the three types of prisoners that Newt stated, and stated very clearly, for those of us on the ground floor in states and who are in the political process, the question becomes, how do we explain to everyday folks who want to be safe in their neighborhoods how we make the determination of what category prisoners fall in? Is there a working model where we can begin to say, well, this person just made a stupid mistake, or this person has skill deficiencies and we're undereducated, or this person is definitely predatory? Is it the rapidity of the person in the system, or is there any other science at work here?
I think Andy and I can answer. I'll just start off by saying in the legislation that we did, one of the problems we had was the task force discovered this. We didn't know what a violent crime was, and nobody knew. And I can tell you from my side, prosecutors and judges considered manslaughter a violent crime. Department of Corrections did not. So the example I gave, Department of Corrections let him out with all this time as opposed to a day-for-day sentence. Point being is we ended up defining what was a violent crime. So we came out with a list. Manslaughter became a violent crime. So we delineated between violent and nonviolent. So with that being the delineation, now it's just like Representative Snowden said, that certainty was put into place. And you can say this is a violent, this is nonviolent. The nonviolent are basically your property crimes, your drug offenses. We reduced, like Andy said, the penalties on your drug cases because what we've seen is that, a lot of the drugs are because they're addicted. Okay, it's not, and they come back because it's an addiction issue. And drug courts had a success in our state. So on the legislative side, we made that delineation and put certainty into the system, and you can say kidnapping, aggravated assault, they're violent crimes, and this is what the sentence is, the others are nonviolence. And I think Andy can answer on a screening process.
Yeah, just briefly, I mentioned the Administrative Office of Courts is developing the best practices for our drug courts, for those nonviolent offenders who find themselves, frankly, in bondage to drug and alcohol abuse. There is a scientific screening process that is available, and it actually is a grid-based system, and not everyone is a good candidate for a drug court. But this system that is out there, well, it is going to be implemented on the front end with respect to our nonviolent offenders in Mississippi, and some of the other states may actually have experience using it, but we just are aware of it and are in the process of implementing it right now.
There is actually two things that have happened since Texas did our things that changed what's going on in the various states. One was the setting up the commissions like Mississippi did, which we didn't do. We weren't smart enough to do that, I guess, at the start. We didn't do it that way. But the second thing is a tool called risk assessment. And I will tell you, there are great tools that have been developed to do exactly the type of thing you ask about who should and what should be there, is actually individualized, like Newt was talking about, an individual plan for each individual. You can actually do those things with risk analysis tools to help you determine which category does that person fit in.
We redid the probation parole, and through the legislation, each offender gets a personal plan, so to speak, that Department of Corrections has to follow. They create a plan for them. It's putting the human side of it back into sentencing. They're not just a number, and I think that was what he's saying, and we did that on our legislation. Thought that was it's very important.
With the drug courts, Ken, if Judge Alm was here to tell you, he'd say maybe a Reagan maximum, trust but verify. Conservative principle, what Speaker Gingrich said was personal responsibility. I'm in recovery for addiction. You know, I'm a former Speaker of the House in Michigan. I see people we call shooting moves all the time, talking a good game, and the rest of it. But you've got to hold people accountable on a daily basis for their behavior, and that's where a lot of the reforms in Mississippi and other states have transitioned to. If you put somebody in jail or prison for a year, well, there's no real accountability, there's no measurements of character development or behavior change. But if you tell them that they have to test every single day, well, then you're going to know every single day whether or not their behavior is changing. And that's what the move with a lot of these things, I would call it filtering. A lot of these policies are the judges and the prosecutors can't tell by looking at people or how they talk or even in how they fill out a questionnaire, but they can tell whether or not you're staying sober and changing if they test you every day. And so when you hear enhanced probation, enhanced parole, that's really what they're talking about is we're going to hold you accountable every single day, and that's where a lot of the change is verified. I just wanted to answer that one specifically for you.
Part of what strikes me, if you really dig into thinking about every prisoner as a human being and as an American citizen, and not just as a number, and you really look at what's not working. One of the side effects of the way we've dealt with mental health over the last 30 years is we have closed state hospitals and put them in prison. And so if you look at the percentage of people in prison who have substantial mental health problems, it's breathtaking. If you add to that the number who also have drug or alcohol addiction problems, and then you add to that the number who can't read, and if you had a score and you said, okay, we're going to give you a score based on do you have a mental health problem, do you have an addiction problem, and can you read, you'd begin to understand that these are people who need, each of them needs a totally different model. And the reason I cited Carly Fiorina's model, and I do a lot of work, wrote a book called Breakout, and really talk about that the smartphone is the beginning of rethinking all public policy, because you can start to have a real relationship. There was an experiment run in Utah where people who'd signed up for drug rehabilitation were getting randomized calls on their cell phone from a computerized voice that encouraged them to hang on for 1 more hour. It turned out 1 day at a time works for alcohol, but actually it's about 1 hour at a time for some drugs. Right? And so you're looking for totally new models, and I would simply encourage that everybody think about today's conference as being sort of about like the Wright brothers about 1906. You know, we're going in the right direction. People are doing very interesting things. We, I think, have begun to turn the corner on it being okay to think differently about this whole issue, but we haven't even scratched the surface of the potential that's out there. If you combine spiritual strength with things like faith-based ministry, with highly personalized interactions off things like smartphones, with an ability to reintegrate the person, so you're dealing with the totality of the human being, you really could be 10 or 15 years from now in a stunningly different world. Again, it wouldn't be a crime-free world, and I'm very tough on people who are violent criminals. I mean, I think there are people you simply have to seal off and say, you ain't getting back in society because you're dangerous. But there's an amazing percent for whom that's not true, and with the right coaching and the right support. But let me ask the Mississippians, because you guys have come a long way down the road, and I want to congratulate several of you for being honest about the fact that stopping and thinking struck you initially as a really strange idea, but that it turned out it was really helpful. Well, I mean, I think that's true of all Americans. I mean, Americans like to pull out the maps shortly after they're lost. They're not big on starting the trip by looking at the map. Here's a question I'd ask for all of you to just comment for a second. If a state came to you and said, given the journey you've been on, what lessons do you think you've learned that we should apply in our state, in our legislature, and how should we approach it? What would you tell them?
I can answer that. That the prosecutors will be your biggest opposition. And this is coming from a prosecutor who's introduced legislation for the Mississippi Prosecutors Association. I think everybody can tell you, Andy Pugh, our biggest hurdle once we got to the bill was the prosecutors. And we overcame that a couple ways. One was it started in the task force by getting the mandatory minimums. Okay, that bought us leverage with the prosecutors, because if we had not done that, we wouldn't have even talked about the other stuff, because they understood the distrust in the system. And it was also recognizing that they were kind of losing, I don't want to say power, but it was with that, and we had to get it back to the human side of it. And you know, I ended up, the leader of the prosecutors negotiation was my former boss, so that became interesting. But it also, you had a relationship there, and so I think it's learning that the prosecutors and understanding, you know, why this was a success, because we had something for everybody. And I know that may sound a little bad, but the prosecutors got mandatory minimums and trust in the system, and we changed the sentencing and other things. But the other side, we lowered the drug penalties, as an example.
Yeah, I would also say that one of the things that we did right in this process is that the governor, the Speaker of the House, and I were all on the same page. And so while there are individual prosecutors or individual conservatives in our state who may not like me or one of the other two gentlemen, when taken in totality, that certainly was very helpful. The other thing that I would say that's very helpful, and I mean this in all sincerity, and that is it's helpful, this right on crime effort. It's helpful when David Keene, it's helpful when Speaker Gingrich, and it's helpful when Alec is on board. I mean, that helps in terms of keeping, from a political standpoint, because the details, as you can tell, are the responsibilities of these individual legislators. My role is to make sure we have the votes on the floor of the Senate to get this passed. And I will tell you, this particular group and the strength that you bring to the process really matters. And I think for other states and other legislators who are thinking about tackling this, you need to utilize the resources in this room, because it will help you long term in ensuring that you get it done. And then the final thing I will say, is we also were very, very inclusive, not only of members of our party, all four of us are conservative Republicans, but we also included our friends on the other side of the aisle as it relates to this. The chairman of corrections in the Mississippi Senate is an African-American Democrat. The bill actually went through the Corrections Committee in the Senate, and he was very supportive because, again, the process that we put in place, the year-long study committee that I originally would not have liked, as was so eloquently put by Speaker Gingrich, we sat down and we thought about it, but we had all of the interested parties in the room, and that really, really allowed for us to have buy-in from all interested parties, and that was so important at the end. And it wasn't easy, by the way, but at the end, when it actually got done, it was because of those efforts that had been put in place a year in advance.
And I would just to relate a war story on that. So, and like a lot of our legislators, we have Tea Party members there, and to the governor's point, so while it was going on, I had one of those members ask about, well, this is soft on crime and all that. And I presented the right on crime and pointed out the signatories of Grover Norquist and Newt Gingrich and Rand Paul and Mike Lee. And it's like, oh, okay. And once they heard that, you know, it was sold. So, and also, Andy, as you heard from Representative Snowden, has handled a lot of the conservative bills in Mississippi. He was leadership on there, and just from the outside looking in, I think with his politics, that helped it along in the House and Senate.
If I can add very briefly, conservatives have credibility on these issues because it's known that conservatives do recognize that there are some people who should be locked up and that crime should be punished. We all have our favorite things, but and I think that the pointing out of the prosecutor's opposition and where you need to come from is important. Our friend from Michigan mentioned Steve Alm, who was able to institute reforms in Hawaii precisely because he had been a tough on crime prosecutor, and when he went to the bench and then realized what was going on, he was able to sell policies that somebody else might not have been able to sell. The same would be true in Mississippi. So I think it's very important that be something that's included. And questions and comments, please identify yourself, because some of us, though we should know you, don't recognize everybody.
I'm Dennis Baxley from Florida, Judiciary Chair, and we have made some progress. But the one thing that seems to be an ultimate measure of success is reduced recidivism. How long do you think it takes the changes that you're making to be reflected in the reduction of the recidivism rate? Because ultimately, I think that's the convincing measure, and if you get everybody culturally measured onto that and saying, if we're reducing recurring crime, then we're winning. And that makes all these other numbers work. How long does it take you to carry these new policies to feel like they're reflected in your recidivism numbers?
One of the things we're also doing with Pew, with their results first wing, if you will, and Andy mentioned it, is we're trying to have an evidence base to all we're doing. And in performance-based budgeting and program-level data, we're building now a structure with a new computer network that we have, but also requiring the judges and municipal courts and everything to build in the data. We'll be able to know what programs work and what don't. And one of the key things, and probably the key thing, as you know, as you just said, is recidivism is one of the really probably the leading indicator of what's succeeding and what's not. The problem we've had, and I suspect a lot of other states have had, is you don't know which particular programs. First of all, we don't even know how many programs we have in the state of Mississippi. You can ask an agency, they have no clue. One of the things we're doing is requiring them to inventory their programs, and we're going to evaluate them based on data. We've had some preliminary looks at corrections, and some of it's not real encouraging. We know from the literature, for instance, that drug courts work if you do it correctly. I want to say the literature supports about a 17%, I may be wrong, but I think that's about right, 17% on average reduction in recidivism, whether you've got a drug court that's working correctly. We found out, Governor, at a Legislative Budget Committee subcommittee last week, and it was looking just at one circuit court district, their drug court. When you have all the overlays of the cost-benefit analysis that goes into a performance-based budget analysis, we're finding in that particular drug court, for every dollar we spend, we're getting 38 cents of real benefit. So something's not happening there, and what we found is not happening is they're not following the best practices that this law that we've just passed that's going into effect on July 1 will enforce them to do that. And as Representative Gibson has said, if they don't, we're going to give them a period of time to get it right, because we know the model works if they do it the way it's supposed to be done. But it's not a drug court just because you call it a drug court. And I would like to say also, I think the essential thing is you have to come to grips at some point that if you have a system that solely based on the amount of money you have, or even primarily based upon the amount of money you have that the state has to spend, if you're basing decisions on how long someone's incarcerated on that, that's a pretty good definition of injustice, and that's just something that's got to be changed.
Yep. Let me say, as Texas has one advantage, we did it first, and we've got data. And that's the good point to have. So first of all, make sure every state has data that they can collect on it. Where do you find out? Well, the first place I found out was we had this prison population expectation, the curve that says how many were going up, and within a fairly short period of time, that stopped increasing. It stabilized. That was the first clue, but it was not the answer to your question, because it's going to take a period of time. It is probably going to take, if you measure recidivism based on 3 years, you're going to have a year before they're released from the programs you have in the prison. You're going to have a 3-year measurement. You're probably looking at 4, 5 years before you get a true set of numbers. But there are indicators that you can look at. Texas has several of those indicators. First of all, our parole things are amazing what's happened in parole. When we started this in 2005, we had a parole rate of about 23% from our parole board. They were looking at about 22,000 people a year, and in that year they had 11,000 revoked from parole. This year, this last year's figures, they had a parole rate of 36%. They're going from 23 or 24 to 36%. They were looking at more people in the system, somewhere around 23 or 24,000, I think. And we had parole revocations of 5,900 and dropping. We had gone from 11,000 practically in 2005 to only 5,900 revocations, and we were paroling a lot more people. That's a good set of indicators. Our probation rates have had the same kind of effect. We have fewer people on probation. And we have as was pointed out, we have a safer community. We have a crime rate that's continuing to drop. All those are factors that you get. But it's going to take you 4 or 5 years to see the recidivism, and it might not be big numbers to start with. It may be just little numbers that you see the first few years. Right? It may be. Depends on how well your system, confidence they have in your system. Because the biggest thing was the confidence we got from our parole and probation people, that we had given them the tools that they needed to, first of all, keep people. Oh, by the other little factor we measured on, we've got, when Governor Perry talked about 17,000 more prisoners we were going to have, they haven't shown up. The 5 years he gave us till 2012, they never showed up. We didn't have that kind of increase, and we closed 3 prisons. Put them all together, and there's a set of indicators that you can use if you do the broad-based things that these guys have said. They'll see it. They may not see it tomorrow or the next day, but they'll see it at some stage and be able to recognize the fact. You won't know which ones are all working as well as you'd like to know, probably. You probably won't have all the data you'd like to have. They'll probably say that, but there's opportunities that are there, and you'll be able to get those somewhere along the line. And somewhere, it's a leap of faith that sometimes you have to take, that you got to believe in the numbers, the statistics and the data. But once you have the data and you believe it, all right, and you have enough faith in it, it happened.
Let me ask, Ken Cuccinelli has a real background and has looked at this from a prosecutor's standpoint, has looked at it as a potential governor. Ken, would you comment on how you see all this evolving?
Before I went to the dark side and went to law school, I was an engineer. And I'm a numbers guy. And it is a whole lot easier to have faith in something you have data for.
Ken, it's a matter that engineers have taken over from lawyers and doing a lot of this thing.
We can only hope. But I think that, you know, I joked a lot in Virginia about there are sometimes you want to lead and there are sometimes you want to follow. There's a natural tendency because the policy we're talking about, criminal justice policy, is made in every state in the political arena. And that provides a level of accountability, but it also it introduces problems. And I would say one of the most significant of those problems is the elevation of hyperbole over data. And it's not unique to criminal justice issues, but go ask a legislator what they're thinking about when they're voting on a criminal justice bill, and very high on the list, if you run truth serum through them, is they're picturing their opponent's political hit piece for anybody whose punishment goes down. And in my 12 years in Virginia, I was on the courts committee when I was in our state senate and then was attorney general. In those whole 12 years, I cannot think of a single instance of a penalty going down. Not one. And the way the bills come is one at a time. And so ideally, your criminal justice system is this long, graceful upward slope from litterbug to murderer and treason and so forth. But the way the bills come is it's one item somewhere on this curve. And some judge has given what some legislator believes is an inadequate sentence to some horrific example of injustice of, you know, cockfighting, to think of one in Virginia that has been in the news in other states lately. And so all you do is look at this one thing, and they tell you about how great the world will be, of course, if we just throw these people away and lock these people away and throw away the key. And it's done with no reference to what's next to it. So the data that Jerry's talking about, I think, is so critical. It's what, frankly, attracts me to the right on crime approach, is evidence-based. I'm not soft on crime, and I know nobody here would admit to being soft on crime either, but I do want to be right. And I do believe that there is a limit to money. Thankfully, I come from a state background where that's legally imposed. I wish it happened at the federal level. But one thing that is immutable at the federal level, and that is math. You can legislate away all you want. You cannot legislate away math. Ask the Greeks. And this is a very expensive proposition depending on which policy courses you choose. So I'm very interested in advancing the data-driven approach. It has proven very difficult in Virginia, and it's you know, I'll observe I'm a conservative. I find that most of my fellow conservatives don't think government does much right, but somehow we don't think it does anything wrong when we get to criminal justice, and that's just flatly incorrect, and defies every other experience that we have in government. I think there's a lot of room for improvement here.
We're going to come back after the break with my home state governor, who, it was pointed out earlier, has a great deal to say about what he's done in Georgia. So, but this is a great opening. I want to thank everybody who participated. And again, Pat, you and everybody else who's been a co-chair, this is a terrific start. Thank you.